is. Sorry. Nope, all good. All right, ma'am, are you Lee Coney?
Yes, ma'am.
And so we've got two cases here. We've got 25 DCCR 1274, which is a new offense. And then there is 24 DCCR 1600, which is an MTRP. We were previously here in the motion to revoke case. And we were set for a hearing this afternoon. And Miss Coney, was previously here. It entered pleas of true to count 3, 4, 6, and 7. Got an updated pre-sentence report. First of all, have you both had an opportunity to review that report?
Yes, sir.
Yes, we have.
Okay, any additions or corrections to that?
No, Your Honor.
Not from since.
And so what I'll do is let's go through the new case since there's an agreement, and then I'll go through the sentencing and that MTRP so that I know exactly what's going on. And will she waive the formal reading of the indictment in the new case?
So moved.
Ms. Coney, in cause number 25, DCCR 1274, you're charged with the state jail felony offense of possession of a controlled substance from September 12th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them? And do you understand if I follow this agreement that you will be waiving or giving up any right to appeal?
Yes.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
And it looks like the agreement that you've reached is for a 20-month term in the state jail prison. And the state would run concurrently with that motion to revoke case in cause number 24, DCCR 1600. Also, the state has agreed not to file cases that are that have been, I guess, received but not filed yet on an offense date of November 1st of 2025. Is that
They
correct?
have not yet been received, Your Honor. The
Okay.
labs are pending.
Okay, same types of offenses.
Yes.
They're on fences.
Yeah.
All right. Is that your understanding of the agreement?
If-
State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Ms. Coney is not competent?
Not that I'm aware of, Your Honor.
All right, ma'am. In cause number 25, DCCR 1274, I find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with that agreement to a term of 20 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And so then there was no agreement in cause number 24, DCCR 1600. Is it the, I guess, recommendation at this time that I sentence her in accordance with what that plea was?
Yes, Your Honor.
So the 20 months would
20
be
months
the,
concurrent with 1274 and refuse the 2, which
Gotcha.
I anticipate to be state jail and Class A.
okay. All right, then, based on that, then Ms. Coney in cause number 24, DCCR 1600. Well, let me ask you, initially this was unagreed, and so there was a right to appeal, but it sounds like there's now an agreement and some things that the state has done and given, I guess, in exchange for that. And so is it your understanding, and do you want me to follow that agreement now for a 20-month term in that motion to revoke case?
That's correct, Your Honor. She waives appeal.
So I am going to have you sign a document that shows that this is now a plea bargain, and so you've waived your right to appeal, and then I'll go forward.
So. Yep.
All right, so then I'm going to find that you entered your pleas of true to counts 3, 4, 6, and 7 freely and voluntarily. Find those counts true, and at this time find sufficient evidence to find you guilty and find you guilty of theft of property. Sentence you in accordance with this new agreement to a term of 20 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run together consecutively at the same time. The state agrees in both of those, not
Judge,
concurrently, concurrently. So they will run at the same time. And the state will agree to refuse the two cases from November 11th of 2025. I'm handing you in each of your cases the trial court certifications that shows that these were agreements that I followed. And so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. All right, thank you. Good luck to you, ma'am. Thank you, Mr. Kimler. Thank you, Ms. French, for y'all discussing that and working it out.